Welcome to our Devry Smith-Frank Insurance webinar. We are thrilled that you have joined us today. We have a great lineup for you of topics and presenters. 2020 has been a highly unusual year. It has been the year we've been hit by the COVID pandemic, which has impacted us all personally, professionally, our businesses, the justice system. Michelle Cook will speak to us about how this has impacted the changes of the rules of civil procedure and how the rules have changed to facilitate better access to justice and better administration of justice. Spoiler alert, electronic communications have been normalized and the fax machine has been put into extinction. We will then have George Frank do a cameo and talk about the importance of witness statements and how to use them strategically. Cindy Leung will give an update about some key accident benefits decisions that took place in 2020. I will then jump in and provide an update on the Ontario court decisions of 2020 and 2021 that I feel will be of most interest. George Frank will then wrap up this webinar talking about insights about how to resolve claims in this brave new world. I'm sure you will have questions. What I will ask is that you hold your questions and you email either myself or the speaker who gave the specific topic where you have questions directly. We will be happy to respond after the webinar. All right, let's get started. Let me introduce Michelle Cook. Michelle is a 2019 call. While she is just at the beginning of her career, she's a powerhouse and one to watch.
Hello, everyone. My name is Michelle Cook, and I'm a lawyer with the law firm Devry Smith-Frank. I've been with the firm for approximately 4 years, having summered and articled at the firm. I am now a lawyer in the commercial litigation and insurance group, and primarily practice in the areas of casualty, subrogation, and bodily injury claims. Today, I will be speaking about the changes to the rules of civil procedure that came in effect on January 1st, 2021. I'll also be providing a refresher on the changes to the rules in relation to simplified procedure that came into effect in January 1st, 2020. The new changes to the rules were announced in November of 2020, and they came into effect on January 1st, 2021. Litigators have had time to incorporate these changes, though notably some lawyers continue to practice under the old rules. The legislation added, changed, or removed 50 different provisions. It is one of the biggest changes to the rules in quite some time. However, several of the changes were minor, largely updating the rules to facilitate a more modernized, electronic, and remote method of litigation in light of COVID-19. In light of the changes, several forms have been updated. It is important to take a look at your precedents and make sure that they're compliant with the rules. As a refresher, the simplified procedure rules came into effect on January 1st, 2020. If you may recall, the monetary limit for simplified procedure claims increased from $100,000 to $200,000, excluding interest. The monetary limit for small claims court rose from $25,000 to $35,000. New limits have been placed on costs and disbursements in simplified procedure actions. A litigant's costs are capped at $50,000 and their disbursements are capped at $25,000, excluding HST. Within 60 days of filing a statement of defense, the parties need to have a settlement discussion. The time for oral examination for discovery has also increased from 2 hours to 3 hours to reflect the increase in the monetary limit under the simplified procedure rules. Mandatory mediation is also implemented for some courts. Jury trials are not permitted unless the action is for slander, libel, malicious arrest, malicious prosecution, or false imprisonment, which are permitted to proceed under the ordinary procedure. There's also been some new limits on trials, which came into effect in 2020. Simplified procedure trials cannot exceed 5 days. The action is to be set down for trial no later than 180 days from the first defense or notice of intent to defend. It is important to properly diarize these dates. A pretrial conference date will be set within 180 days of the action being set down for trial. At least 30 days before the pretrial conference, the parties will have to agree on a trial management plan that contains a list of all witnesses, including experts, and divides the days between openings, examinations in chief, cross-examination, and closings. Specifying the method of attendance at hearings, mediations, and discoveries is now mandatory. While previously parties were required to specify the attendance at hearings, mediations, and discoveries in documents such as the notice of motion, mediation brief, and notice of examination, the courts have now explicitly required parties to specify the method of attendance for all steps in the litigation. While telephone and video conferencing has always been available, the court is especially focusing on adjudicating matters remotely where possible. For instance, case conferences are deemed as per the rules to be held via telephone conference unless a party objects. Nevertheless, I've had some case conferences proceed via Zoom as that was the preference of the adjudicator. If the parties disagree with the method of attendance, they must formally object to it within 10 days after receiving the notice of method of attendance or 7 days before the hearing, whichever is sooner. If no objection is received or the objection is not made in time, the rules presume that there was consent to the method of attendance. If an objection is properly filed, the method of attendance is to be determined in a case conference, which will presumably occur via telephone. The increased availability for telephone and video conferencing means less need for in-person court attendances, which saves on travel time and unproductive wait time. This saves our time and, more importantly, our clients' money. Electronic signatures are now explicitly set out in the rules. A document that may or must be signed by the court, a registrar, a judge, or an officer may be signed with an electronic signature. The rules do not comment on whether lawyers can have electronic signatures, though notably a lot of lawyers have been incorporating them. Emails are also the new faxes. Service by email is now permitted for most documents that are not an originating process. Service by fax has now been removed, and the reference to providing a fax number has been removed for most documents, including the front and back pages. Service by courier is now permitted. It was previously not acceptable service, although often used. The courts can also issue and certify documents electronically. These electronically issued and certified documents constitute the original. Lawyers can notify electronically issued documents by making reference to the email from the court enclosing the document. CaseLines is an online document management system. It does not constitute e-filing, but assists the courts and other parties in organizing the documents. All courts, including appellate courts, now use CaseLines, especially for contested hearings. For instance, the divisional court uses CaseLines to monitor compliance with their case management orders. Certain steps must be taken, such as agreeing to a timetable, before the courts will provide a hearing date and CaseLines access. If it is not in CaseLines, it does not exist. What I mean by this is you cannot presume that a judge has seen the materials, even if they've been e-filed. Most contested hearings involve CaseLines. If counsels have been directed to file materials in CaseLines, all materials should be in CaseLines, including cost outlines, draft orders, factums, affidavits of service, and other documents. The judge will not have access to the e-filed materials. Depending on how old the matter is, it may be necessary to upload documents that were previously physically filed into CaseLines. Litigators should also be prepared to litigate via CaseLines references. All litigants are assigned a letter, and page numbers are given by CaseLines. It's easier to rely on this marker, even if you don't have numbered documents, or even if you do, such as in a factum or a motion. Hyperlinks and naming conventions are particularly important with CaseLines litigation. All documents should be in CaseLines at the time the motion confirmation is due. The document submitted to CaseLines should be exactly the same as the document that is e-filed or physically filed with the court. This is great because there's no longer a need to make costly and time-consuming copies of motion records and other large documents. It is far more electronically efficient to just work with the case lines, and it ensures that all parties are looking at the exact same document. The rules have also been modified to require parties to participate in pretrial conferences and case conferences, not just attend. Participation implies more than just being a present warm body. Presumably, the courts want more matters settled before proceeding to the trial, or at least have the issues limited. Clients and claims examiners will now be participating more actively in the process. Before, clients would show up at pretrials, would be left in the hallway while the parties had a discussion, and if lucky, would be called to the room to hear the outcome by the judge. Now clients are invited and expected to be more involved in the pretrial conference, particularly as we expect judges to come and try to settle the matters more aggressively. Draft orders and endorsements. The rules have been expanded to permit more leniency on how and on what documents judges can make endorsements, which I have often seen are in separate documents or just a scan of handwritten notes. The rules also explicitly require the parties to provide a draft order of the relief sought in advance of the hearing. So the main takeaways: telephone and video conferences are available if anyone requests them. If either party objects, it will be resolved at a telephone conference. Everything can be done electronically. This includes issuing, filing, copies, orders, signatures, emails, and other documents. There is no fax. CaseLines is the new software to manage litigation and documents. If it is not in CaseLines, it does not exist. And parties are required to participate in pretrials and case conferences. They're no longer required to simply attend. I'm now passing this presentation over to George.
Thanks, Michelle. Hello, my name is George Frank. I do litigation and mediations. I've been practicing for over 40 years, primarily in the personal injury field. Today, I'm going to talk about best practices in witness statements. Witness statements should be obtained as soon as possible after the incident, giving rise to the need for the witness statements. The likelihood of locating the witnesses is going to be highest immediately after the accident or incident, and of course, diminishes over time. It's more likely that the witnesses will have a good recollection and a precise and accurate recollection of the incident if the statements are obtained very shortly after the incident, and the witnesses' recollections become very unreliable quite quickly. Don't wait until preparing for trial to obtain witness statements. You want to have the witness statements available for the pretrial conference, for mediation, and even for examinations for discovery, if possible. In some cases, obtaining witness statements immediately after the incident, where there is a possibility of litigation, but none has been commenced yet, may be sufficient to dissuade the other party from pursuing a claim at all, and may totally eliminate the need for litigation. Statements should generally be obtained from all liability witnesses. Don't rely on the witness statements in the police accident report. They can frequently be inaccurate or incomplete or ambiguous, and you want to make sure that you pin down the witness to an accurate version of the events as soon as possible. So if you have the information, the contact information for the witnesses from the police accident report, you should then try to get a signed statement from each of those witnesses in which you will ensure that the information you need for the litigation will be set out in detail and with accuracy. Statements should also be obtained from any potential damages witnesses. Now, often these are not identified until examinations for discovery, when you can ask the plaintiff questions about their coworkers, their neighbors, their friends, etc. Statements should then be obtained from those people as soon as possible, again, so that the statements are available for the mediation and for the pretrial. Don't wait until the courthouse steps to get statements from these witnesses. Where statements are obtained from an independent adjuster, These statements should be reviewed carefully to ensure that they provide all of the necessary information and that they are sufficiently detailed and sufficiently unambiguous for use at trial and at the pretrial and mediation as well. Ask yourself the following questions. Does the statement pin down the liability issue adequately? Is additional information required? Is there scope to challenge the witness on cross-examination at trial? If so, additional information should be obtained from the witness to clarify whatever the contentious issue is so that the witness will be protected from cross-examination at trial if possible. If any additions or revisions are required to a witness statement, these should be pursued diligently. A copy of the revised witness statement should be provided to the witness so that the witness can review it and confirm that the revised statement is indeed accurate. And if possible, the witness should be asked to sign the revised statement. The rules of civil procedure require disclosure of the names and addresses of all persons having knowledge of matters in issue in the litigation. A summary of the evidence of those people is also required. If a statement is obtained from a witness, the statement itself is privileged, and that statement can be used at mediation or at pretrial without prejudicing the privileged nature of that statement. Except in rare circumstances, a copy of the statement itself should not be provided to opposing counsel. There are some cases where the statement is so clear and not subject to attack that it's a good idea to provide it to the opposing counsel so they'll know exactly what the witness has to say. But in most cases, the statement itself should be kept privileged and just the information in the statement should be produced to opposing counsel. The statements should be listed in Schedule B to the affidavit of documents, which lists all the privileged documents. If the statement has been provided to opposing counsel, then it's less of an issue that it be listed in Schedule B, but it could still be listed there. Prior to trial, one may want to use a statement to assist a witness in refreshing their memory. It's important not to just provide the statement to the witness and say, here, read this over to refresh your memory, because at trial, opposing counsel may cross-examine that witness by asking them if they refreshed their memory, and if so, what they used to refresh their memory. At that point, opposing counsel can insist on production of the statement and can use that statement to cross-examine the witness. The better practice is to take the information in the statement and discuss it with the witness to refresh the witness's memory. That way, the privileged character of the statement itself won't be lost. At trial, should opposing counsel decide to call that witness to give evidence at the trial, the statement you've obtained from that witness can be used to cross-examine the witness. So there you have some best practices for witness statements. Hopefully you'll find them to be helpful. Thank you very much for listening. Now, Cindy Leung is going to talk about some recent developments with respect to accident benefits. Cindy was called in 2017 and has practiced in the personal injury field since her call to the bar. She is our most recent addition to our defense group, and we welcome Cindy to our defense practice. Cindy.
Hello, everyone. My name is Cindy Leung, and I am a lawyer practicing mainly in the area of personal injury litigation. Today, I will be going through 5 lessons we have learned from the accident benefits and LAT decisions over the past year. So, at a glance, the 5 issues we will be covering today are as follows, and I will go through them one by one. The first issue today deals with an interesting story where an insured was caught in a lie by the insurance company through a phone call that she made to her broker. And the problem was that this phone call was recorded without her consent. So at the LAT, the adjudicator focused the analysis on two parts. The first part was whether or not this phone call contained information that demonstrated material misrepresentation. And number two was whether or not this phone call recording should be admitted into evidence because there was no consent from the insured for it to be recorded. So for the first part of the analysis, the adjudicator looked at three issues and basically found that there was material misrepresentation. Number one was that she could not provide the bills to prove where she lived. Number two is that she had moved and changed addresses for more than a year without telling Economical where the new address was. And number three was that the insured was involved in a car accident while driving to work in her own vehicle, when in fact she had told Economical that she was only going to take public transit to work. So all of these factors and then some led the adjudicator to conclude that there was in fact material misrepresentation. So on the issue of whether the recording should be admitted into evidence, the adjudicator found that it should because the probative value outweighed the prejudice to the insured. And of course, the Statutory Powers Procedures Act basically mandated that the rules of evidence in the LAT were relaxed, and therefore the adjudicator was entitled to admit it into evidence. So based on this conclusion, it was found that the insurance company did not have to pay the insured her IRBs. The second case deals with the calculation of IRBs, and in the face of fishy tax returns, whether or not these returns could be relied on for this calculation. And this insured was employed in a family auto shop business. And because of the questionable tax returns, Economical had asked for further documentation to more accurately calculate his IRBs. However, the disclosure request was not completely complied with. And on this basis, Economical argued that based on section 33 of the SABs, that IRBs were not payable since the disclosure request was not totally complied with. And to be fair, Economical had a fair point. For one, the insured with his bookkeeper were the ones who decided how much to report as income to the CRA, and his bank deposits did not match his CRA tax returns. So the adjudicator agreed with Economical that yes, there were issues with his income financial information. However, he tried to strike a balance and said, as long as he provided his notices of assessment, then he would be entitled to IRBs for those periods. And so in the end, IRBs were only awarded for the period of 2016 to 2017, and IRBs were not awarded for the periods he did not provide notices of assessment for. Moving on to the next issue today, we are now dealing with the issue of how much IRBs an insured has to repay when there is willful misrepresentation. And in this case, which is a little more recent in 2021, this insured was not forthright as to when she returned to work. And she was caught on surveillance going back to work as a waitress from September to November of 2018, being around 2 to 3 months. And she was caught going to 9 shifts. So on this basis, it was found that there was willful misrepresentation in the written submissions that were submitted by Aviva, because she not only failed to advise of Aviva, she had actually perjured herself and on record told the IE assessors that she was unable to go back to work when in fact she was. So it also was determined that Aviva had met the notice requirements and that because of the willful misrepresentation exception, that the lateness in sending out a letter asking for repayment of the IRBs was not fatal to Aviva's case. So because Aviva submitted written submissions and the fact that the insured failed to submit her own written submissions, this meant that the insured forfeited her right to defend herself and also failed to give the additional documentation that Aviva had asked for earlier in this case. And so because of all these factors, it was impossible for the adjudicator to really decide when she went back to work. And for this reason, it was ordered for her to repay all of her income replacement benefits, even before September 2018, where there was surveillance footage, because it was not possible to determine when she went back to work. and so she had to repay all her IRBs with interest. The fourth issue we're going to discuss today concerns IE assessments. And basically, the adjudicator in this case reiterated that it is very important to have strict compliance of Section 44 sub 5. And basically, the adjudicator stated that when an insurer sends out a notice of examination for any IE assessment, that there must be clear reasons stated in that notice of examination to the insured so they know why they need to attend. And it is not sufficient for the insurer to just say reschedule on the notice of examination or to expect the insured to make an inference as to why this exam is important based on past correspondence. So the report that came out of this improperly scheduled examination was excluded in this case, and it was found that the treatment plans were reasonable and necessary, and we will never know what the adjudicator would have found otherwise if only this report was not excluded. The last issue that we will be discussing today deals with the definition of incurred expenses. And for this, we have to go through a bit of history. So this case came from a Superior Court of Justice trial after a failed fiscal mediation. And the trial judge initially awarded about $300,000 in attendant care and housekeeping expenses that were deemed incurred using a broad interpretation grounded in the case law and was informed by contra proferentum and consumer protection principles. So Wawanisa disagreed with this conclusion and argued it was too broad, and on appeal, the Court of Appeal revisited the definition of incurred. And so in visiting Section 3 sub 7, this, according to the Court of Appeal, provided the guidance as to how the word incurred should be construed, and we should follow the statutory definition of incurred because the case law is outdated. So for this reason, the Court of Appeal reduced the $300,000 awarded to approximately $29,000 only because the plaintiff had only paid out $29,000 and therefore only this amount was deemed incurred. As for the next part, the Court of Appeal then looked at Section 3 sub 8 and had to investigate this to see if there was any unreasonable behavior or delay from Wawanisa that warranted the expenses to be deemed incurred because of this behavior. And so the plaintiff alleged that the report from Wawanisa came out late, and therefore this formed the basis of Section 3 sub 8. However, the court found that there was a misunderstanding of the evidence because actually the delay was not Wawanisa's fault and there were cancellations and adjournments that were out of the control of both sides. However, the court did not let off Wawanisa just yet because Wawanisa was found to have had some reliance on a medical report that was controversial according to both sides. And so the Court of Appeal found that this issue was a live issue and was not investigated thoroughly enough at trial, and for this reason ordered a new trial to investigate whether or not Wawanisa did the right thing in relying on this report that was deemed controversial. So going forward, it seems that Section 3 sub 8, outlining the reasonable or unreasonable delay of insurers, is still a live issue, and we will have to wait until the new trial comes out to determine whether or not Wawanisa's actions can be construed as reasonable or not reasonable in defining whether the expenses were incurred. So as a summary, the 5 issues that we have discussed today are as follows. Number 1 is whether or not a phone call from an insurer that is recorded without their consent can be relied on in a LAT hearing. And the answer is yes, if the probative value outweighs the prejudicial value. Number 2 is how are IRBs to be calculated when there are questionable tax returns? And in response, the answer is they can actually be relied upon because if it is good enough for the CRA, it is good enough for the SABs. Number 3 is the issue of how far back an insured has to repay if there is willful misrepresentation. And the answer is that an insured may have to pay back some or all of their IRBs, depending on what they can prove. Number 4 deals with IE reports. And basically, strict compliance is necessary, or else the report may be excluded. Number 5 is dealing with the definition of incurred. And basically, an expense can only be deemed incurred if it has been paid out based on section 3.7. However, based on section 3.8, the interpretation of this section remains to be seen based on a new trial that may come out in the future for Pucci versus Wawanisa. So this concludes my presentation for today. Thank you very much for listening. And I will now turn it over to Miriam Tepperman, who is our host. Miriam has been practicing insurance defense litigation for 18 years, and she will be going through some important and recent decisions coming out of the Ontario Superior Court of Justice, as well as the Ontario Court of Appeal. And I will pass it over to Miriam.
All right, I will jump into my topic of advising you about various interesting issues that have come out of the Ontario Superior Court as well as the Court of Appeal since beginning of 2020. So one issue that they've been dealing with a lot is the issue of whether a jury notice could be struck. So our already overloaded system faced the increased challenges and pressures that the COVID pandemic has brought with it. So the questions become, can jury notices be struck in this context? And when should they be struck? The Court of Appeal has sent a really strong message in this regard. They have considered two cases, Belton and Spencer and Leung and Poitras. In both these cases, the courts have underscored that it is the trial judge who has a wide discretion to make these decisions. The question is whether the moving party has shown that justice will be better served by discharging the jury. The paramount objective of the test is that the civil justice system is to provide the means by which a dispute between the parties can be resolved in the most just manner possible. A right to a jury is fundamental, but it is not absolute. And when faced with these difficult practicalities, the right to a jury trial sometimes has to yield to what is practical in the circumstances. And the court has reminded us that both a single judge and a jury labor under the same duty to do justice impartially and dispassionately. And they have to judge based on the evidence before them. So in the Belton case, the Court of Appeal found that where there were no jury trials being heard, and it might be at least a year or 18 months before a jury trial might be heard, that it was reasonable where there was a judge available the following month to strike the jury notice and order a judge alone trial. And Leung and Poitras, again, they looked at the decision of the judge and they said, the judge had looked around and said, okay, it might be at least 6 months before a jury trial can be heard. Even then it is questionable because there might be one courtroom and one jury room available. So it'll be one jury trial at a time, does not know when it'll be heard, but there is availability for judge alone trials. And the judge and the trial judge therefore struck the jury notice. What is interesting is how the appeals process worked after both trials. And the main lessons that we need to learn is that an appeal of striking a jury notice goes to the divisional court, not to the Court of Appeal. A decision from the divisional court can then be brought to the Court of Appeal. And the reason for this is it's an interlocutory issue, and that's the proper jurisdiction of the divisional court. That said, the Court of Appeal has made it very clear that the trial judges have a lot of discretion, and in these unusual circumstances, they're going to really look to that discretion. And unless they are, testing on the wrong principle or acting arbitrarily or capriciously, the trial judge's decisions will hold. So what we will see, will we see more jury notices struck? Yes. Doesn't mean all jury notices will be struck. No. There was one case in Toronto where the jury trial was allowed to proceed. because at the time jury trials were still being heard. So it's really going to depend on the circumstances. And from the messaging of the Court of Appeal, we're going to see that where it's, slightly questionable, they will rely on the judge's decision. And really, I would expect it would have to be an egregious decision for it to be overturned. All right, so now we'll move on to the next topic, which coincidentally happens to be related to jury notices as well. So the question is, what happens to a jury notice when a matter is moved down from the ordinary procedure to simplified procedure? So Michelle has discussed the changes in simplified procedure in her presentation. So let me just highlight what sort of applies specifically to this case that I'm about to discuss. Okay, so in simplified procedure, jury trials are no longer available. A trial cannot exceed 5 days, and a trial must be by summary trial only. And that refers to the specific rules of evidence and how it can be presented at trial. So for example, there will no longer be direct examination of witnesses or experts. Those will all be by way of affidavit. The only thing that will take place during the trial from that perspective is cross-examinations. So when the rules of simplified procedure changed, there were transition provisions. And one transition provision was that if there was a jury notice delivered before January 1st, 2020, when the new amendments came into effect, then it was an exception and a jury would still be allowed. The problem is that the implications of the transition are unclear. How does this work? How does it come together? So the judge in Lightfoot and Hodgins really emphasized, there are questions of how do you make it work? Does a jury trial, do you have a jury trial in simplified procedure? Do the jurors then get the affidavits? Do they have to read all the affidavits by themselves? Is that included in the 5 days? Is that in excess of the 5 days? How does it work? So Justice Mazinski, my apologies, agreed with the approach that was raised in a master's motion by Master Suganasiri that says, if you require the jury, you have the right to a jury, but then the matter stays in ordinary procedure. And if you strike the jury, you can now proceed under simplified procedure. And Justice Mazinski agreed in Lightfoot with that approach. So this was the endorsement that the jury notice is struck when the matter is moved to simplified procedure. We may see appeals. I am not sure the status in that regard, but what we do know is that based on COVID and what is happening, it seems, I would suspect it's unlikely that the court will take a different approach. Now moving along to the next topic, expert assessments. In Brooke and Cooperators General Insurance Company, a second expert assessment was considered. This case took place during COVID, but is not directly related to COVID. The way COVID, excuse me, interplays here is that a pretrial had taken place. The trial had been adjourned due to COVID and not to this motion. And during the interval, the defendant wanted a second assessment. So there aren't necessarily new principles here, but it is a good refresher because I suspect we will see more COVID motions, more expert assessment motions going forward. All right, so taking a look at the principles, purposes of attending a second medical examination is discretionary, and its goal is to ensure the fair determination of disputes through an even playing field. The party seeking the order for further examination must demonstrate the assessment is warranted and legitimate. So what factors are considered legitimate? All right, has a party's circumstance changed or deteriorated to such an extent from the previous exam? Has there been so much delay that a more current assessment has been required? And by delay, I just mean time lag. Third possibility is the plaintiff has served a new assessor report and the defendant should have an opportunity to respond. And another one is that some injuries fall outside the expertise of the first examining expert, and that needs to be considered as well. So in this particular case, the plaintiff had 6 reports, including a physiatry report and a future care cost report. The defendants wanted a second assessment. They had initially gotten an assessment by a neurologist and now wanted an assessment by a physiatrist. So the pretrial had taken place, but the trial had already been adjourned. So this was not a cause of the adjournment. It's just a matter of how the courts would deal with it. And plaintiff's counsel here was interesting because they said, we'll withdraw our physiatrist report, so you don't need to get your physiatrist report. But the key here is their future care cost report depended on the findings, opinions, conclusions of the physiatrist, and they were not withdrawing their physiatrist report, their future care cost report. So the court indicated in this circumstances, it is reasonable for the defendants to get their second examination and granted it. All right, moving on to our next topic, limitation periods and third-party claims. So Albert Bloom Limited and London Transit Commission considered this issue. So this was an environmental contamination case. Statement of claim was served in May 2013, and it was defended in 2014, January 2014, and the third-party claim was issued against Eaton in March 2016. So Eaton brought a summary judgment motion arguing that the claim against it was discoverable and that London Transit Commission is out of time. What is noteworthy here, and will come into play later in the decision, is that Eaton stopped owning the adjacent property in 1973. So the judge held that discoverability runs from the date of the statement of claim. It is a rebuttable presumption, and if the the party wishes to rebut it, they are able to do so and have the onus of showing the claim against a third party was not discoverable until data was served, until a later date. All right. Well, the question here was, did the London Transit Commission do enough investigation? Had they done the investigation? Would they have discovered it? So the court deemed constructive knowledge at the time that the statement of claim was served. The other question was whether testing actually has to be done to show contamination before the litigation period begins to run, and the court said no, having the allegation is sufficient. So the last thing, and this is where Eaton's ownership rights become an issue, is that London Transit alleged that this was a continuous tort, and so the third party claim was similarly based on the continuous conduct, and so the limitation period did not expire. Well, the court looked at that and said, well, no, Eaton stopped owning the land in 1973, and so for a claim to be continuous in that sense, the legal injury itself must continue and not just the ill effects. So those are the lessons that we have learned from the Albert Bloom case. Now, moving along, internet harassment. Is this a new tort? According to the Superior Court of Justice, it is. The law of defamation provides recourses for the targets of some types of conduct, but they're not sufficient to curb the wrongdoing behavior of the wrongdoer. The posts have negative effects on self-esteem when someone is cyber stalking and posting about somebody else, and they can cause depression and anxiety. So they're not victimless crimes. So the judge held that the purpose of the tort of internet harassment is to recognize that it's not just about defaming someone, but it's to harass them. Put another way, the intent is to go beyond character assassination. It is intended to harass by repeated and serial publications of defamatory material, not only of the primary victims, but to cause further distress by targeting persons those primary victims care about. So it causes fear and anxiety and misery. So in this case, Atlas had not only defamed the targets, but also went after family members posting pictures and very untrue, ugly statements about them. So I expect that we will hear more from the courts, and this is just the beginning about whether this is a new tort and how the courts will deal with it. But at this stage, we definitely have food for thought. And now moving along to the next topic, my last topic is, can a historical sexual abuse claim settlement be set aside? Can it be reopened? And in Lalonde and Deschênes, the answer was yes. So in this case, Deschênes was sexually abused as a child by a priest, Mr. Sylvester, who was a priest with the Diocese of London, Ontario. She, as an adult, later sued the church, and in 2000, a settlement was reached. That settlement was reached based on the information from the diocese that they had first learned that there were possible issues with Sylvester about child abuse in 1989. And so there was no way to prevent the abuse to Deschênes that happened prior to 1989. They said they couldn't have known about it, they couldn't have prevented it, and a settlement was reached. Well, we fast forward now from 2000 to 2006. Documents came to light that the diocese had been notified in 1962 of at least 3 possible girls that had alleged that Mr. Sylvester had sexually assaulted them. There were also earlier complaints. So the information that was provided was by the diocese and formed the basis of the settlement was not accurate. So Deschênes then brought a new litigation. She commenced new litigation for misrepresentation. And as a result of this litigation, the diocese's settlement was set aside. It was determined that the diocese knew at the time of the 2000 settlement about the earlier police records relating to the 3 other alleged victims, and that they had not taken the steps to disclose it. This was then appealed to the Court of Appeal, and the Court of Appeal dismissed it. And it was then appealed to the Supreme Court of Canada, and it remains unchallenged. So we now see a case, here's one case where a historic settlement in historic sexual abuse claims has been allowed to be reopened. I suspect over the recent years, we have seen more information come out, more transparency about what various dioceses knew at different points in time, what various churches knew at different points in time. There is so much more openness and communication about sexual abuse and even physical abuse that we may see an onslaught of new cases reopening. So only time will tell, and we'll have to keep our eye out to see what happens in that regard. All right, I will now pass the floor back to George. Well, George may have begun his practice of law before fax machines were even invented. He is the consummate litigator. He evolves with the changes and adapts to his strategies accordingly to remain a leader in this industry. George will give us tips on how to take advantage of the technological changes to harness more expedient resolutions in our matters. Thank you.
Thanks, Miriam. Hello again. With the light shining at the end of the COVID tunnel, I'm going to give you some strategies for resolving claims in a hopefully soon to be post-COVID world. As we've heard, the courts have finally started to adopt technology. The electronic age is finally upon us. The Chief Justice of Ontario has said there is no going back. The changes that have been forced upon us by COVID are going to continue beyond COVID. There will be no return to the old way of doing things. Michelle has talked about the changes to the rules that came into effect January 2021. These amendments to the rules codified some of the COVID practices that had been implemented by the courts. Priority is going to be given to telephone and video conferences rather than personal attendances. Documents will be issued and filed electronically. Email will be the preferred method of communication. Faxes have gone the way of the dodo. Although the rules have permitted video and telephone conferencing for decades, they had not been adopted until COVID. Now that COVID has forced them upon us, we will hopefully see them continue into the future. And the need for personal attendances for such things as trial scheduling, court, and the like, hopefully is a thing of the past. Since the onset of COVID, examinations for discovery have generally been conducted by Zoom conferences. Out of necessity, lawyers have developed the necessary skills to conduct an effective examination for discovery by Zoom. Although many counsel initially had concerns about the possibility of inappropriate conduct by a witness on an examination for discovery, there have not been significant problems. Virtual examinations have proven to be an effective way to conduct an examination for discovery and frequently take less time than an in-person examination. Travel time has been eliminated. Particularly in a personal injury matter, the credibility and likability of the plaintiff are crucial elements in assessing the claim. Although the ability to assess credibility and likability at a virtual examination for discovery is not quite as good as it is at a face-to-face examination, counsel are coping with it. And we can foresee that examinations for discovery are going to continue to be conducted virtually in most routine cases. Catastrophic cases or cases where there are real substantial credibility issues may be exceptions. Some counsel prefer to meet with their client, their insured, their witness, in person while conducting the examination of the opposing party by Zoom. So we'll see once COVID is over to what extent that practice continues. Mediators have been very creative in ensuring that mediations continue to be available during COVID. Mediators are taking advantage of the features available on many video conferencing platforms for breakout rooms and caucusing. They are generally reporting a similar success rate in resolving cases with Zoom mediations as had been their experience previously with face-to-face mediations. Many defense counsel and adjusters lament their inability to assess the plaintiff at a Zoom mediation and feel that this is an impairment to their ability to get claims settled. But nonetheless, cases seem to be settling and counsel and adjusters have figured out how to work with the current regime. We can expect face-to-face mediations to resume to some extent once COVID is over. But at the same time, many lawyers and adjusters have gotten used to working remotely. And we will see to what extent the desire to participate in a face-to-face mediation is balanced by the ability of the counsel and adjusters to work remotely when they're doing mediations by Zoom. Face-to-face meetings have generally not been available to discuss settlement of claims during COVID. There seems to have been little effort by most counsel to arrange Zoom conferences for this purpose, but most lawyers are making up for this by having telephone discussions and using email to discuss settlement of claims and are getting claims settled. So we can foresee that this is going to continue. Will insurance companies want to reinstate their settlement conferences? Usually these were held near the end of the year with a view to seeing how many claims could be settled prior to year end. If so, Zoom conferences could make these extremely efficient and would eliminate the need for rental of space or hotel rooms to conduct the settlement conferences, and would enable adjusters to meet with lawyers in numerous different locations via Zoom without the need to travel or the time required for the travel. Telephone probably remains one of the most useful tools in resolving cases. The back and forth discussion that can take place during a telephone conversation is much more effective than exchanging multiple emails back and forth without the sort of live interplay between counsel. Eliminating jury trials in civil actions has been the discussion in Ontario for over a century. Civil jury trials were eliminated in Quebec in the 1970s. Other provinces have restricted the availability of jury trials in different types of civil actions. The reasons given for eliminating jury trials include expense, the time required to conduct a jury trial, excessive use of court resources, and delays caused by the jury trials. In Ontario, we already have numerous restrictions on the availability of jury trials. They're not available in defamation actions. They're not available in actions for a declaration. They have now been taken away in simplified procedure actions. In Ontario, 3/4 of jury trials arise from motor vehicle accidents and other personal injury cases. Generally, jury notices are served by defense counsel in most personal injury matters, although in some cases, jury notices are served both by plaintiff's counsel and by defense counsel. With the COVID-19 pandemic shutting down the courts, jury trials have been virtually unavailable for over a year now. As mentioned by Miriam, the Court of Appeal has made it clear that the entitlement to a jury trial will not be allowed to impede the timely trial of civil actions. So while jury trials continue to be unavailable, we can expect the courts to continue to order that actions proceed to trial without a jury. The question remains what approach the courts will take once COVID is over. It's certainly foreseeable that the reasons given for abolishing jury trials will be used by the courts to eliminate jury notices in specific cases. And it also remains to be seen whether the Ontario government will further restrict the availability of jury trials in civil actions. It will probably be about 2 years from the time of the first court closures due to COVID before things are completely back to normal. During this time, counsel have been largely unable to try cases and certainly unable to conduct jury trials. So will this 2-year hiatus have an impact on counsel's willingness and ability to try cases? It's difficult for counsel, particularly junior counsel, to get experience at jury trials at the best of times. COVID will result in a further 2-year delay. We will hope that COVID doesn't result in a lost generations of jury trial lawyers. Thanks for listening. I'm going to turn things back over to Miriam again. Miriam?
Thank you, George. That was very insightful. We thank you all for joining us today. If you have any questions or would like to discuss any of the topics further, please reach out to the speaker or to myself. We will be happy to continue the discussions. Everyone, please stay safe, stay healthy, and we hope to see you in person in the not too distant future.